Senator Cruz.
Thank you, Mr. Chairman. Welcome. I think one of the worst legacies of the Obama presidency was the politicization of the Department of Justice during the 8 years of the Obama-Biden presidency. The Department of Justice has a long history of being apolitical, of exercising fidelity to law, of not being used as a partisan weapon to target the enemies of whichever administration is in power. The Obama-Biden administration corrupted that process, and we are still dealing with the consequences. I believe appointees to the Department of Justice should have a demonstrated record of fidelity to law and impartiality, an ability to defend the rule of law. Ms. Gupta, as I look at your record is one of an extreme partisan advocate. Your record is an ideologue. Now, there's a role in our democratic and political process for ideologues, for people that are extreme, radical advocates. That role, I believe, is not being the number 3 lawyer at the Department of Justice in charge of the impartial and fair administration of justice. As I look at your record on every single issue, the positions you've advocated for are on the extreme left, and you've demonstrated an intolerance for and hostility to anyone that disagrees with the extreme left political positions. On the issue of abortion, is there any restriction whatsoever on an abortion that you believe is permissible?
Senator, first, let me begin by saying I'm sorry that you feel that way. As a lifelong civil rights advocate, my duty has been to enforce the Constitution, not enforce anyone's political agenda or partisan agenda. I have apologized today for some of the harsh rhetoric that I've used, and I mean that
and I'm not focusing on your college years. I'm focusing on as an adult and practicing lawyer. But let's just start with a substantive question. Is it permissible for the government to prohibit partial birth abortion? Yes or no?
Senator, my duty, if confirmed, will be to federal laws and the Constitution. Roe versus Wade is established precedent and has been reaffirmed numerous times by the courts. And my duty will be to enforce the federal laws and the Constitution.
Okay, so you're declining to answer that. How about the Heller decision, which upheld the individual right to keep and bear arms, a fundamental right in the Bill of Rights? Was Heller rightly decided?
Senator, Heller is the law of the land, and I will enforce Heller as
so you're not answering that either. All right, let's shift to a different topic. Religious liberty. You've demonstrated significant hostility to religious liberty. You have defended the Obama administration's targeting and persecuting of the Little Sisters of the Poor. Not too long ago, religious liberty was a bipartisan commitment in Congress. The Religious Freedom Restoration Act was introduced by then Representative Chuck Schumer. It passed the House unanimously. It passed the Senate 97-3 and was signed into law by President Clinton. Now, today's Democratic Party has abandoned religious liberty. Indeed, the Equality Act, of which you are a vocal supporter, that has now come out of the House of Representatives, is a radical piece of legislation that, among other things, explicitly repeals significant aspects of the Religious Freedom Restoration Act to take away our religious liberties. You have been a vocal defender of the Equality Act. Do you agree with the provisions stripping RFRA's religious liberty protections from Americans?
Senator, let me begin by saying that religious liberty is incredibly important to me. I am a person of faith. My family is one of deep and abiding faith. And this country's founding freedom was rooted in religious liberty. I have defended religious freedom throughout my career. When I was at the Justice Department, I launched an interagency effort to protect religious liberty.
Ms. Gupta, I appreciate that, but our time is limited, so if you could answer the question I asked.
It's only fair to allow her to complete her answer.
Mr. Chairman, I understand that she has things she wants to say, but I asked if she supports the repeal of RFRA. That's not
Senator,
the question.
if you want to make a speech, you may make a speech.
I'm asking a question. I'm asking a question, and she's giving a speech, and I understand that you support her nomination, so you're giving a speech too. But I'm asking a question.
I'm asking you to allow her to answer.
She was not answering. She's welcome to answer the question. The question is, Do you support the Equality Acts repealing RFRA's protections of religious liberty for Americans?
Senator, I support RFRA. I have enforced provisions of RFRA, and the Justice Department must enforce the law. The Justice Department enforces religious liberty and protects it. It also enforces our nation's anti-discrimination laws.
Let me try a third
on the
time. Do you support the Equality Act's repeal of RFRA's religious liberty protections?
Senator, if confirmed as Associate Attorney General, my duty will be to enforce laws to protect religious liberty and the anti-discrimination laws that the Justice Department
Okay, so you're declining to answer
enforce.
that as well. Let's move to another topic, which is school choice. Your tenure at the Department of Justice demonstrated a radical hostility to school choice, such that the Department of Justice intervened in a case trying to kill a Louisiana school choice program there, even though many African-American parents strongly supported the program. The Black Alliance for Educational Options was fighting on the other side. The federal court at issue there specifically reprimanded the Department of Justice under your leadership for ineffective lawyering, that's a quote, and for attempting to, quote, circumvent the ordinary litigation process in order to regulate the school choice program without any legal judgment against the state. Do you regret using the Department of Justice to fight against the school choice program that was providing hope and opportunity to low-income minority kids in Louisiana?
Senator, I have dedicated my life to fighting for opportunity for low-income children of all communities in having educational opportunity. Again, as I said, my duty, if I am confirmed as Associate Attorney General, will be to enforce the law and Constitution. And I have to look at the facts and laws of any
Ms.
particular
Gupta,
situation.
you're still not answering the question. That's been let's move to another one. At the beginning of this hearing, Chairman Durbin asked you about abolishing the police, and you said, I do not support defunding the police, which is clearly the right political answer seeking to get confirmed. I would note that just a few months ago, last year, in written correspondence with the Senate of the United States, you encouraged Congress to, quote, re-examine federal spending priorities and shrink the footprint of the police and criminal legal system in this country. And you also encouraged reallocating resources and stated, quote, some people call it defunding the police. Other people call it divest, invest. But whatever you call it, if you care about mass incarceration, you have to care about skewed funding priorities. These were not college writings. This was about 8 months ago that you wrote this to the Senate. By any measure, that's advocating defunding the police, and yet today you're telling this committee you don't support that.
Senator, respectfully, I disagree with how you're characterizing that. I don't support defunding the police. I've been very clear about that. I have
Were the quotes
enjoyed,
I read
if I may, sorry?
Were the quotes I read inaccurate?
Well, let me, if I may, can I tell you what those statements reflect conversations that I've had with sheriffs around the country, police officers, police chiefs, civil rights activists, who have been talking to me for years, long before, as I said, the events of this summer, about the fact that we have placed so many of our nation's social problems at the feet of police. And we have defunded mental health services. We have defunded substance use services. We have expected law enforcement to be the only go-to solution. We have given, in many communities, only one response available for when we have family members in crisis or with drug addictions. And this is an issue where it is one that I think really unifies law enforcement and civil rights advocates and community leaders who are seeking alternatives to incarceration for addressing some of these very challenging questions, and sheriffs who are frankly fed up with the fact that their jails are 70% filled with people who are suffering from mental illness.
With all due respect, I don't believe you have been speaking to sheriffs who are advocating for defunding the police, and I've spoken to far too many sheriffs to find that credible. Thank you.
Senator Klobuchar.
Thank you, Mr. Chairman. Ambassador, welcome. Thank you. So, Ambassador, you and I have had a good working relationship. We had a very good conversation in my office. We have worked together, in particular, concerning humanitarian crises and dissidents. I appreciated your willingness when serving as UN ambassador to speak out for Miriam Ibrahim, who was wrongfully imprisoned in Sudan and sentenced to torture and death for the crime of being a Christian. And you showed courage speaking out for her. As you know, I was very frustrated President Obama wouldn't speak out for her, but I was grateful that you did. But I also had very significant disagreements with you during your time as UN ambassador, and nowhere were those disagreements stronger than concerning Israel and concerning Iran. Concerning Israel, I think perhaps the most shameful moment of the Obama administration was after the election in November of 2016, and was the Security Council's passage of Resolution 2334, which I do not think it is coincidental that the Security Council passed it after the presidential election and not before. And that resolution was passed with, at best, the acquiescence of the United States and of you as UN ambassador, and at worst, the active encouragement of the Obama administration and you as UN ambassador. I believe Resolution 2334 is a pile of lies, that it is a resolution that is motivated by anti-Semitism, by hatred for Israel. Resolution 2334 declares much of modern-day Israel is illegitimate and illegally occupied territory. It declares the Jewish quarter in Jerusalem is illegitimate and illegally occupied territory. It declares the Wailing Wall is illegitimate and illegally occupied territory. There's a much circulated picture of President Obama in a yarmulke paying respects at the Wailing Wall. To see the Obama administration put through a resolution designed to attack Israel was quite dismaying. So I guess my first question is, do you agree with Resolution 2334?
Thank you, Senator. There were two sort of guiding principles that I relied upon as UN ambassador as it relates to Israel. The first was to combat bias and anti-Semitism and the unfair way that Israel has been treated at the UN and is treated at the UN. And the second, following President Obama's direction, of course, was to preserve space for a two-state solution. I want to make sure I have the chance to just describe a little bit what I did, and I'm disappointed we didn't get to talk about this in your office, what I did in the first category, because I think your question does not reflect the reality of my 4 years at the UN.
With respect to Ambassador Power, the time is limited.
Right.
And so if you could just answer the question I asked, do you agree with Resolution 2334? I recognize you may well have done other things that were positive concerning Israel. I'm focused on this action at the United Nations.
I just would like to get on the record that under my leadership, we secured Yom Kippur as a UN holiday. We convened the first ever General Assembly condemning anti-Semitism in the same chamber as the Zionism as Racism resolution was passed decades before. And we integrated Israel in a way that had never been done before, chairing committees, being able to actually be part of groups from which they had been traditionally excluded. I don't think there is a record that looks as substantial when it comes to integrating Israel. On the resolution itself, it is a resolution in keeping with President Obama's desire to encourage the parties to avoid unilateral steps, including terrorism, incitement to violence, and the building of settlements. Those dimensions of the resolution, I think if you read my explanation of vote at the time, the problem with the resolution and the reason President Obama decided to abstain was by and large the venue, because the UN has been so biased, because there are 18 General Assembly
resolutions. Let's get to a little bit more granularity.
Yep.
Do you believe the Jewish quarter in Jerusalem is illegitimate and illegally occupied territory?
I do not.
So do you disagree with the substance of Resolution 2334? Because that's what it says.
Senator, President Obama's desire was to encourage the parties to avoid unilateral steps. That is the essence of that resolution, and I think the reason that he made the judgment to instruct me to abstain.
So encouraging the parties to avoid unilateral steps, Resolution 2334 was a unilateral step. Israel had no say in it. It was a step taken by the enemies of Israel to condemn Israel.
Again, the desire that animated me in my time at the UN was to fight bias and to preserve space for a two-state solution.
Okay, a final question. Can you please describe the role played by Iran and by the Houthis in particular in deepening the humanitarian crisis in Yemen and assess whether the Biden administration's moves to relieve terrorism sanctions on the Houthis has played a role in that humanitarian crisis?
The Houthi, when I was at the United Nations, the Houthi overran a sovereign government, used military force for territorial acquisition, have used food as a weapon of war. I mean, again, I'm on record condemning Houthi actions and specifically, again, the use of humanitarian aid. I think the challenge is the vast majority of Yemenis live under Houthi control at the moment, unless and until there is a political settlement. And so it's really important, given that that's the world's largest humanitarian catastrophe right now, that we find a way to get food to those vulnerable people.
But
Thank
the
you
Biden
very much.
administration's lifting the terrorism sanctions
So
make
the
it worse?
senator's time has expired, and
I was just asking her to answer.
I know
the question.
I've let more time than other colleagues.
Okay, I'd still like her to ask the question.
I'm sure you can submit it for the record, and you'll get a response.
Okay, so you don't.
No, I want to observe the time I have for everybody else.
She could still.
Senator Booker.
I am really grateful. We're all juggling hearings.
Mr. Chipman, a minute ago, Senator Whitehouse asked you if any of your views on guns are out of step with the majority of the American people. The AR-15 is one of, if not the most popular rifle in America. It's not a machine gun. It's a rifle. Your public position is that you want to ban AR-15s. Is that correct?
Senator, thank you for the question, and thank you for our visit yesterday and offering me a Dr. Pepper. It made me reminisce about my time in Central Texas. But now to your question. With respect to the AR-15, I support a ban as has been presented in a Senate bill and supported by the President. The AR-15 is a gun I was issued on ATF's SWAT team, and it's a particularly lethal weapon, and regulating it as other particularly lethal weapons I have advocated for. As ATF director, if I'm confirmed, I would simply enforce the laws on the books, and right now there is no such ban on those guns.
So you want to ban the most popular rifle in America. A minute ago, and you noted there is a Senate bill. Senator Feinstein had a bill to ban some 2,000 specified rifles and other firearms in her bill. In 2013, the Democrats had a majority in the Senate. It was the Harry Reid Senate. And we voted on the Senate floor on Senator Feinstein's so-called assault weapon ban. Do you know how many senators voted for it?
No, I do not.
40. 60 voted against it. So in a Democratic Senate, a supermajority voted against a ban. Now, part of the reason they voted against the ban, as you're aware, is during the Clinton administration, there was a ban in effect. The Department of Justice studied the effect of that law and discovered that it had no measurable impact on violent crime. Is that right?
Senator, I did enforce this law for 10 years as an ATF agent. I'm unfamiliar with the study that you are pointing out, and I apologize for that.
Well, when you and I met in my office last night and discussed it, I asked if there were any data to suggest that the ban was effective, and what you said in the office is you were not aware of any data, that the data was, I think, mixed is the term you used.
Yeah, yes, Senator. What I said to you yesterday, you've accurately stated it. I think it was mixed, which, I stand by that remark. And I think my recollection is that evidence was shown that the limitation on magazine size had an impact. I also believe that later studies showed that the use of assault weapons in mass shootings had declined during that period. That's how I would like to characterize my views on that.
So you also said when you and I talked yesterday in the office that Senator Feinstein's bill, which a supermajority of senators voted against in a Democratic Senate, you said that bill didn't go far enough and you wanted an even broader ban to ban. You said it didn't go far enough. Is that right?
Senator, thanks for that question and the ability to clarify. What I did say is that Senator Feinstein's bill did not address those firearms that are currently in the possession of Americans. And then I did share with you my view as an advocate, which would be quite different than someone actually enforcing the law in the books, that those firearms could be treated under the NFA and regulated that way, which would deal with those currently in the possession of Americans.
So when you say it didn't go far enough, you mean that you don't just want to ban the manufacturer of those rifles, you don't just want to make it illegal to sell those rifles, but you want to actively have government go after the people who currently possess firearms, and if they don't register and submit to all of the onerous restrictions of the National Firearms Act, presumably confiscate their weapons?
Senator, what I've said publicly is that as an advocate, I prefer a system where the AR-15 and other assault weapons are regulated under the National Firearms Act.
Let me shift to Ms. Jaddow. You and I also had a conversation this week. Do you consider so-called birth tourism to be a problem?
Thank you, Senator. Thank you, and thank you for taking the time to meet with me yesterday. I really appreciated that. We did have a quite fruitful discussion on that issue, and I believe we ended with the thought that we need to collect some information, and the data is not there. I also noted that as a mother and as someone who's been through quite a difficult delivery, the incredible interest in protecting the health of a mother, the health of a new baby, and ensuring that we could do the best we can so that women and their babies are protected.
Ms. Jaddow, with all respect, I don't find that answer remotely credible. And you said in my office you didn't consider birth tourism an 8-month pregnant or 9-month pregnant woman getting a tourist visa to come to America to have a child on American soil, so that child is an American citizen, that you didn't consider it an abuse of our laws. It's an obvious and transparent abuse of the laws. I will point out last December, federal prosecutors indicted 6 people running a birth tourism operation in Long Island, where Turkish women would pay between $7,500 and $10,000 to travel to New York on tourist visas to give birth and return to Turkey with American citizen babies. And in 2019, the New York Times referred to the birth tourism industry as, quote, thriving. Is it your position that this doesn't occur, that the New York Times was wrong, that there's not a blatant abuse of our immigration system?
To the extent that anybody is committing fraud or assisting in anybody committing fraud or misrepresentation, that has not only makes someone inadmissible to the United States, but also there are criminal penalties. And I understand, I'm not familiar with the case you just mentioned, but I'm familiar with other ones that a sister agency inside the Department of Homeland Security in the past, Immigration and Customs Enforcement, has addressed.
Thank you.
Senator Klobuchar.
Thank you very much.
Mr. Holgram, let's start with you. If confirmed, you would be the principal intelligence advisor to the Secretary and other State Department principals. You would be charged with driving the intelligence apparatus, advising the Secretary of State on the risks and the benefits of re-entering any nuclear deal with Iran. I want to ask you about that. One of the most troubling aspects of the catastrophic Obama-Iran nuclear deal were the enormous holes in verifying Iranian compliance. Some of those holes were obvious, such as giving Iran weeks to clean up sites before inspections and functionally prohibiting inspection of military facilities. Others were less obvious, but even more damaging. One side deal forced the IAEA, the United Nations nuclear watchdog, to prematurely close investigations into past Iranian nuclear weapons work, leaving the scope and the nature of Iran's weapons program unknown. According to Bloomberg, the Obama administration provided Congress with a classified annex saying that the deal could still be verified if Iran fully complied and didn't cheat. Today we know, of course, the deal failed to detect vast portions of Iran's nuclear weapons program. We know it because of daring raids and revelations by our Israeli allies. We know that between the implementation of the deal in January 26 to May 2018, the IAEA was not aware that Iran was concealing a nuclear weapons archive. Nor was the IAEA aware that Iran had containers at a warehouse called Turkozbad, where the IAEA later reportedly discovered traces of man-altered uranium. The agency subsequently visited 3 other undisclosed sites and found nuclear material at 2 of them. The IAEA has never inspected any facility run by the SPND, a military organization employing nuclear weapons scientists, which until last year was run by the founder of Iran's nuclear weapons program. That's unknown sites and 0 military facilities inspected. Despite all of this, the Biden administration is rushing to re-enter the Iran deal. Mr. Holmgren, do you support re-entering the deal in light of those failures?
Senator Cruz, thank you for that question. As a former intelligence analyst who focused on the Middle East, I very much appreciate the multidimensional threat that Iran poses, their state sponsorship of terrorism, their nuclear ambitions, cyber human rights violations, and their ballistic missile capabilities. So I very much appreciate the threat. If confirmed to lead INR, which is what part of the intelligence community, my commitment to you and to this entire committee is that we will supply objective information and analysis regarding all of Iran's malign activities, to include its compliance with the nuclear requirements as part of the JCPOA, even if those conclusions diverge from policy interests, but especially because I think it's even more important if the intelligence community has a different view based on all sorts of information of where policymakers are, that we would absolutely provide that information to support the Secretary, but also other policymakers as well as this committee.
In your assessment, what additional measures would be required to close the loopholes that allowed these failures in the prior deal?
Senator, I'm not privy to I haven't been in government the last few years, so I'm not privy to any classified details and additional measures, but what I could tell you is that from an intelligence perspective, I think having an incredibly strong collection and analytic regime focused on Iran's compliance certainly would be a top priority. As I mentioned in my opening remarks, I view Iran as one of the top big 4 threats we face, and so making sure that INR has the resources and the expertise to provide objective analysis would absolutely be a priority for me, sir.
Okay, and Mr. Crittenbrink, the Obama administration implemented a policy that forbade our Taiwanese allies from displaying symbols of their sovereignty, whether flags or medals or uniforms, on U.S. soil. During the Trump administration, I pressed the Trump administration to change that policy, to reverse the ban, and they did so. Unfortunately, after Secretary Blinken came through his confirmation hearing, where I asked him about it, and he committed to maintaining the policy of allowing Taiwan to display its symbols of sovereignty. Subsequently, the Biden State Department reversed that policy and now prohibits our Taiwanese allies from displaying their symbols of sovereignty. This committee just a few weeks ago took up legislation I had to reverse the new Biden ban and to return to the pre-existing policy that allowed Taiwan, like our other allies, to display their symbols of sovereignty. This committee passed that overwhelmingly. The Senate passed it overwhelmingly in a bipartisan manner. If confirmed, will you restore the previous policy allowing our Taiwanese allies to display their symbols of sovereignty? And if not, why not?
Senator, thank you very much for the question. I want to emphasize at the outset, Senator, if confirmed, I would be absolutely committed to growing our robust and vitally important partnership with democratic Taiwan. I would argue that our partnership with Taiwan is perhaps stronger than it's ever been, from our commitments demonstrated under the Taiwan Relations Act, including $30 billion in arms sales since 2009, to the provision of vaccines to our close health cooperation to the visit by 3 members of the Senate in just the last few weeks. I think we've made clear our commitment to growing that partnership with Taiwan. Senator, since 1979, for decades now, the United States has followed a set of contact guidelines for our engagement with Taiwan. And my understanding, Senator, is for decades now, those guidelines have outlined that during our important engagements with our our Taiwan counterparts to advance our unofficial relationship, that symbols of sovereignty are not allowed on U.S. government property. And those guidelines, as I understand them, Senator, have been in place for decades and were in place for the vast majority of the previous administration as well. Based on the briefings and discussions that I've had, Senator, the new guidelines that have been enacted under the Biden administration are significantly liberalized. They are explicitly designed to further develop our relationships and our partnership with Taiwan, and they have been welcomed by the Taiwan leadership, including President Tsai herself. So I can assure you, Senator, that I am committed in every way to growing our partnership with Taiwan, and I will hasten to add that, of course, I will always enforce U.S. law.
Thank you.
Thank you.
Mr. Chairman, welcome to the nominees.
Thank you.
Justice Robinson, let me start with you. I am concerned about your record, both as an advocate and as a justice, that it demonstrates a marked hostility towards religious liberty. When you were in private practice, you wrote a brief in favor of forcing the Baker family, a Catholic family that owned a print shop, to print membership cards for a pro-abortion activist group. The Baker family believed that was in violation of their deeply held religious convictions. In your brief, you used strong and even incendiary language to describe the Baker family's religious convictions, referring to their views that they did not wish to actively advocate for and promote abortion. You referred to those religious views as invidious and pernicious. As you know, the very first clause of the First Amendment of the Constitution protects religious liberty. Given that history of litigating and attacking an exercise of religious liberty, how might a litigant in the Second Circuit have any confidence that as a judge you would actually follow the law and in particular honor the religious liberty protections in the Constitution?
Thank you, Senator Cruz. Just to put that case in context, and I don't have all the details in my mind because it was 30 years ago. It was my very first year of practicing law in Vermont. But the claim by my client was that she had been subject to discrimination on the basis of her religious conviction. In particular, she had asked to print cards for Vermont Catholics for free choice. Her contention was that the Bakers said, "We won't print these cards because we don't think Catholics can be for choice." She brought a claim for discrimination on the basis of creed, and we acknowledged out of the blocks that if the facts showed that the Bakers declined to print the placard because of their opposition to abortion rather than their belief that her strain of Catholic faith was wrong, then she wouldn't have a claim.
So hold on a second. I have to say you said that clarifies things, but if anything, that makes it worse. So your argument was that if their view was this is the teaching of the Catholic Church, then that the courts should straighten them out and say, no, you don't get to have your own understanding of the teaching of the Catholic Church. We're going to force you to say the Catholic Church is pro-abortion even if you don't believe it is. Is that right?
Senator, the applicable law as stated by Justice Scalia in his opinion in the Smith case was and remains that a neutral law of general applicability applies without...
and that's why Congress passed the Religious Freedom Restoration Act.
I understand that.
The overwhelming bipartisan majority of Congress concluded the Smith case did not adequately protect religious liberty. You likewise during a marriage law symposium said, quote, "Long after every state in this country allows same-sex couples to marry, there will still be churches that decline to recognize or celebrate same-sex marriage. And we're not suggesting that should be otherwise." Well, maybe it should be otherwise, but that's not our mission. I find it quite astonishing as an advocate that you're suggesting that the law has purview to force pastors and priests and rabbis to change what they teach as a matter of faith if it does not fit a political position that you happen to support.
Senator Cruz, I would agree with you. That is not my position. I'm not familiar, as I sit here, with the exact context of those remarks, but when I was an advocate, our position was always that the debate about whether a particular religious community should or shouldn't recognize marriages between same-sex couples was for the members of that religious community to decide. The question of whether the law should recognize marriages between same-sex couples was the only issue of concern for our advocates.
Ms. Sung, do you believe Justice Kavanaugh is intellectually and morally bankrupt?
Senator, I would want every Supreme Court justice to know, including Justice Kavanaugh, that I respect completely their authority as a Supreme Court justice. I would follow their precedents without reservation.
Okay, you're an experienced lawyer. You know when someone's not answering a question. My question was simple and straightforward. Do you believe Justice Kavanaugh is, quote, intellectually and morally bankrupt?
Thank you for the question, Senator. As I stated earlier, I recognize that that statement was overheated rhetoric, and that's all that it was.
Okay, I'm going to try one more time because you signed your name to it, and it wasn't decades ago. It was very recently. You sign your name to this statement. I'm asking simply today, do you believe that Justice Kavanaugh is, quote, intellectually and morally bankrupt? You signed your name to that proposition. Do you still believe it?
Thank you for the question, Senator. As I stated, that was rhetorical advocacy only, that I signed strictly in my personal capacity as a private citizen addressing my alma mater. And throughout my legal career as an litigator, as an adjudicator, I have followed all of the court's precedents.
It is disappointing that you refuse to answer that question. It's a simple yes-no question, and 3 times you've refused to answer it.
Thank you, Senator Cruz. Senator Hirono.
Thank you, Mr. Chairman. I ask all nominees of
Justice that it demonstrates a marked hostility towards religious liberty. When you were in private practice, you wrote a brief in favor of forcing the Baker family, a Catholic family that owned a print shop, to print membership cards for a pro-abortion activist group. The Baker family believed that was in violation of their deeply held religious convictions. In your brief, you used strong and even incendiary language to describe the Baker family's religious convictions, referring to their views that they did not wish to actively advocate for and promote abortion. You referred to those religious views as invidious and pernicious. As you know, the very first clause of the First Amendment of the Constitution protects religious liberty. Given that history of litigating and attacking an exercise of religious liberty, how might a litigant in the Second Circuit have any confidence that as a judge you would actually follow the law and in particular honor the religious liberty protections in the Constitution?
Thank you, Senator Cruz. Just to put that case in context, and I don't have all the details in my mind because it was 30 years ago. It was my very first year of practicing law in Vermont. But the claim by my client was that she had been subject to discrimination on the basis of her religious conviction. In particular, she had asked to print cards for Vermont Catholics for Free Choice. Her contention was that the bakers said, we won't print these cards because we don't think Catholics can be for choice. She brought a claim for discrimination on the basis of creed, and we acknowledged out of the blocks that if the facts showed that the bakers declined to print the placard because of their opposition to abortion rather than their belief that her strain of Catholic faith was wrong, then she wouldn't have a claim.
So hold on a second. I have to say you said that clarifies things, but if anything, that makes it worse. So your argument was that if their view was this is the teaching of the Catholic Church, then that the court should straighten them out and say, no, you don't get to have your own understanding of the teaching of the Catholic Church. We're going to force you to say the Catholic Church is pro-abortion even if you don't believe it is. Is that right?
Senator, the applicable law as stated by Justice Scalia in his opinion in the Smith case was and remains that a neutral law of general applicability applies without...
and that's why Congress passed the Religious Freedom Restoration Act.
I understand that.
The overwhelming bipartisan majority of Congress concluded the Smith case did not adequately protect religious liberty. You likewise, during a marriage law symposium, said, quote, long after every state in this country allows same-sex couples to marry, there will still be churches that decline to recognize or celebrate same-sex marriage. And we're not suggesting that should be otherwise. Well, maybe it should be otherwise, but that's not our mission. I find it quite astonishing as an advocate that you're suggesting that the law has purview to force pastors and priests and rabbis to change what they teach as a matter of faith if it does not fit a political position that you happen to support.
Senator Cruz, I would agree with you. That is not my position. I'm not familiar, as I sit here, with the exact context of those remarks, but when I was an advocate, our position was always that the debate about whether a particular religious community should or shouldn't recognize marriages between same-sex couples was for the members of that religious community to decide. The question of whether the law should recognize marriages between same-sex couples was the only issue of concern for our advocates.
Ms. Sung.
Turn to the ranking member.
Thank you, Mr. Chairman. I want to start with a question for each of the 5 witnesses. In your judgment, are voter ID laws racist? Professor Tolson.
Thank you for that question. So it depends. One thing we have to stop doing is treating all voter ID laws as the same.
Okay, so your answer, I want to move quickly, so it depends is your answer?
Yes, that's my answer.
Okay, so what voter ID laws are racist?
Apologies, Mr. Cruz, your state of Texas, perhaps?
Okay, so you think the entire state of Texas is racist. What about requiring an ID to vote is racist?
So I think, sir, that's pretty reductive. I'm not saying the entire state of Texas is racist.
You just said my state of Texas, so you tell me, what about the Texas voter ID laws is racist?
So the fact that the voter ID law was put into place to diminish the political power of Latinos with racist intent and had been found to have
You're
racist
asserting
intent,
that. What's your evidence for that?
The federal district court that first resolved the constitutionality of Texas's voter ID law.
Okay, so your view is voter ID laws are racist. How about you, Mr. Yang?
I agree with Professor Tolson. Voter ID laws can be racist.
Okay, that's
the
2.
context.
Mr. Science?
There are some voter ID laws that are racially discriminatory in intent.
How about in practice? In intent, fine, you say there's some racist with a malevolent intent lurking in the back of their mind. But let's just talk about it as a practical matter. When I go to vote, they ask me for my ID. I pull out my ID, I show it to them, I vote. Is that racist?
If the law that requires you to do that was motivated by racially discriminatory intent
what about the
under
effect?
our
Set
Constitution.
aside intent. Set aside intent. I'm asking about the effect.
Yes, in effect, I think that there are discriminatory effects from a number of voter ID laws.
Okay, thank you, Ms. Reardon.
I'm going to give the witness a chance to answer the question. Go ahead, Mr. Sine.
Yes, in effects, I think many voter ID laws are discriminatory. And in design, they are designed to have that effect.
Okay, Ms. Reardon.
No, sir.
Mr. Van Spakovsky.
No, particularly because every single state that has passed an ID law has put in a provision to provide a free ID to anyone who doesn't have one. The turnout numbers show it has no effect, and I would remind everyone that the current version of the Texas voter ID law for in-person voting, the Obama administration agreed in court, in a court filing, that they were satisfied with it and that it was not discriminatory.
You know, I have to say this range of question actually shows the wildly partisan nature of the Democrats' proposal. The record should reflect all three of the Democratic witnesses invited by the chairman maintained to this committee that voter ID laws can be, in many instances, in most instances, I think of the various ways they formulated, are racist. So let me tell you who disagrees with that. 35 states across the country disagree with that because 35 states have voter ID laws in effect. But not just 35 states. 81% of voters in America disagree with the radical views proposed by the Democrats and the Democratic witnesses. Not just 81% of Americans. 77% of black voters in America support voter ID laws. 78% of Hispanic voters in America support voter ID laws. Maldev should think about that. 81% of low-income Americans support voter ID laws. And yet, what this bill is about is putting radicals in charge of saying, if you require an ID to vote, that is racist and must be struck down. This is all about partisan power. Now, DOJ has also said, under the Biden administration, that it is not going to presume that a state acts lawfully if it simply returns to pre-COVID voting laws. Ms. Reardon, Mr. Van Spakovsky, what does that tell you if they say after a pandemic, if you go back to the laws that existed before, DOJ is not going to assume that that's okay? What does that tell you about the partisan nature of DOJ?
By issuing the guidance that they did, it says to me that what they would like to do is make permanent the emergency procedures that were instituted by many states through litigation by the DNC throughout the country prior to the 2020 election. And they would like those to be permanent. And so rather than understand that they are temporary, they are going to go after states that designed to go back to their original election procedures.
Well, and I think they also think Democrats did well under those emergency procedures, and so keeping those emergency procedures in place will predictably benefit Democrats. You know, I would note, in addition to disagreeing with the vast majority of the American people, the Democratic witnesses and the Democrats here also disagree with the United States Supreme Court. When I was the Solicitor General of Texas, I represented a coalition of states defending Indiana's voter ID law. Before the U.S. Supreme Court, a group of plaintiffs challenged that. It went to the Supreme Court, and the Supreme Court, by a vote of 6-3, upheld Indiana's voter ID law. Not only did they do so, Justice John Paul Stevens, one of the lions of the left, wrote the majority opinion where he said voter ID laws protect the integrity of elections. And yet, sadly, too many Democrats today don't want to protect the integrity of elections. And I've got to say there is a view, particularly from Northeastern Democrats, that they look down on the rest of the country as a bunch of bigots and overalls, their Southern cousins who are too oafish to be as enlightened as they are. And I have to say there's an incredible hypocrisy in that states like Georgia and Mississippi have a higher black voter registration rate than states like Connecticut, the chairman's home state. They have higher black voter turnout rates than states like Connecticut. They have a lower gap between black and white turnout than in states like Senator Blumenthal's Connecticut. And in fact, states like Georgia and Mississippi, African Americans vote at a higher rate than white voters, and in Texas, they're basically equal. One of the sad realities of today's Democratic Party is they define race as follows. If you're a Democrat, you qualify. So under the Democratic view, I'm not Hispanic. Senator Padilla is. If you're a Democrat, you're an Hispanic. My abuelo and abuela would be very surprised to discover I wasn't Hispanic. But that's how Democrat views it. That's how the radicals in the civil rights division view it, and I will point out as an example. This committee, one new federal district judge in the state of Texas, Jason Pulliam, is an African-American judge nominated by President Trump, sat at this table, presented superbly. The Democrats had no criticism, and every single Democrat on this committee voted against him. Why? Because they perceived him as a black Republican. He didn't qualify as a black man. And I actually asked, as the Democrats were voting against Judge Pulliam, do you have one basis to vote against him? Anything you disagree with? None of them had any single answer at all. This hearing's about one thing. It's about power, and it's about ensuring Democrats stay in power. That's cynical, and it's at the expense of democracy and the right of voters to express their will through free and fair elections.
I'm going to ask my questions now and just begin by saying this hearing has nothing to do with any geographic discrimination, any idea that one state or another is oafish.
Thank you, Mr. Chairman. Judge Koh, welcome. As I look at your record is concerning from the perspective of a judge who will faithfully apply the law. As I look at your record, I see the record of someone who's been an activist her entire adult life. When you were a law student at Harvard Law School, you participated in a 25-hour sit-in in the dean's office, pressing for racial quotas in hiring at law school. At the time, you described your views of judges, where you said the problem of the American legal system was the homogeneity of the bench, and your proposed solution was, quote, minority judges still need to maintain the disguise of objectivity or else face challenges to their decisions. You went on to say, yes, that minority judge is going to identify with their own experiences, but she can't admit this. We've got to get more clever and say, look, we're just as neutral as any 60-year-old white man. What's more pragmatic? To pretend we're objective or to deconstruct objectivity itself? Now, you've tried to back away from that statement since then, but what on earth did that mean?
Let me first say I have never advocated for quotas. Quotas are unconstitutional. As I said, I do disagree with that statement completely. That was 31 years ago. Since then, I have been a federal criminal prosecutor. I have been a judge on the state court hearing 500 cases a week. I've been a federal district judge for almost 12 years, hearing 719 cases a year, and I have 3,250
So my question was, what does that
opinions.
mean? Not how many decisions have you heard as a judge? What did that mean when you said?
No, I'm just saying that there is a record to determine.
Judge, you're familiar with asking questions and answering questions. What did you mean when you said that?
It was 31 years ago. I don't recall specifically, but I'm sure I said, what I said is what I meant at the time. I think it's completely wrong. I disagree with it. That's not how I've lived my life, how I've served
So
the
I guess the
government.
challenge is what you said is that that at the time, when you were in law school, you weren't a child, you were a student at Harvard Law School. You said that judges need to maintain the disguise of objectivity and get more clever and pretend to be objective. And a difficulty for this committee is if you were following that instruction, you'd say the exact same thing right now, wouldn't you?
I am under oath, and I am telling you that I completely disagree with that statement. And you can look at the 271 trials I've had.
Then let's go to your judicial record, because as I look at your judicial record, I am concerned as well. Recently, you determined that a state regulation that banned Bible study, that banned collective prayer, that banned worship in an individual's home, while at the same time allowing activities like in-home commercial filming was neutral and generally applicable. According to you, according to the decision, apparently people who attend Bible study are a greater threat under COVID than movie stars when it comes to health and responsibility. Now, that decision, of course, went up to the U.S. Supreme Court, and 6-3, the Supreme Court said, no, you're wrong. What did you get wrong?
The Supreme Court in Tandon has held that when you're looking at comparable activity, you look at the government interest that's asserted and not the reasons why people are gathering. That clarification has been very important. That is what I will fully, faithfully, and fairly apply going forward. They also
Why
said
did you
can't
think
assume
that movie stars somehow are held to a different standard than people coming to a Bible study?
I was following the Ninth Circuit precedent. They looked at all the restrictions on the movie industry and said that the risk transmission risk was lower because of all the restrictions. They had mandatory multiple testings per week, and they had a lot of restrictions that said that they had scientific evidence that the risk was lower.
Your opinion applied rational scrutiny to this restriction on religious freedom. The Supreme Court reversed that and applied strict scrutiny. There's a world of difference between rational basis and strict scrutiny. Again, why did you get it so wrong? And how can the American people have comfort that if you're a Court of Appeals judge, you will faithfully protect their rights to religious liberty?
I applied strict scrutiny as well, and I was following Ninth Circuit precedent at the time, which said you look at the risks of transmission and you go through 7 factors to consider it. And at the time, the Sixth Circuit decision, which was not enjoined by the Supreme Court, said if you have a neutral, generally applicable rule that applies to both religious schools and public schools and other private schools, that survives strict scrutiny. And so the precedent that existed at the time is what I followed in issuing my decision.
Could you answer my second question?
I fully understand that Tandon is the law of the land. That is absolutely what I will follow, that you cannot assume the worst when people go to worship and assume the best when they go to work, and that you have to look at the government interest at stake, and that all of the rulings and holdings in Tandon, that's the law of the land. That's what I will apply going forward in any case that raises these issues.
Thank you, Senator Cruz. Senator Ossoff, Senator Blackburn, and Senator Padilla.
Judge Koch.
Thank you. Thank you so much for your testimony today, and thank you for your determined and capable leadership of the Civil Rights Division.
Thank
you, Mr. Chairman.
Thanks, Senator Coons. Senator Cruz.
Thank you, Mr. Chairman. Ms. Clark, when you testified before this committee and when Attorney General Garland testified before this committee, you both promised to be nonpartisan and impartial. I'm sorry to say that I think neither of you have lived up to that promise. Within weeks of President Biden being sworn in, the Department of Justice dismissed a Civil Rights Division lawsuit it had against Yale University for explicit racial discrimination. Yale has a policy that discriminates against Asian Americans at admissions. It does so brazenly and openly. And yet, the Department of Justice decided that preventing racial discrimination did not fit within the purview of the Biden DOJ. Now, in your defense, you were not yet there, neither was Merrick Garland. So that was merely the initial political operatives of the Biden administration doing what they believed was consistent with the preferences of the president. But just this week, after you were there, after Merrick Garland was there, the Department of Justice issued a memorandum to the FBI instructing them to mobilize against parents across the country, parents of school kids, who have the temerity to show up at school boards and express their opposition to the teaching of critical race theory, a pernicious theory that divides us on racial lines, that tells school children the lie that America is fundamentally racist, that America is irredeemably racist, that all white people are racist. It spreads racial division. Many parents are understandably quite dismayed at schools that are teaching this to their children, sometimes as young as 5. And yet the Department of Justice looked at that issue and decided to label the parents objecting to this teaching as domestic terrorists. Did you participate in discussions about the memo before it was issued?
Senator, I can't talk about internal deliberations.
You can't talk about whether
inside the
you
department.
participated in discussions about the memo?
No, but what I can tell you is that the Civil Rights Division will play a role going forward. The Attorney General has asked the department to undertake a review, and the division will participate in that review to determine how federal enforcement tools can be used to prosecute crimes.
Do you believe parents objecting to the teaching of critical race theory have civil rights in the democratic process?
I don't follow the question, Senator.
You don't understand the question whether parents objecting to critical race theory have civil rights?
The First Amendment is a core value in our democracy, and
I didn't say free speech. I said civil rights. School board meetings are democratic. They are petitioning your local government. Do they have civil rights that the voting rights gives a damn about?
Yet they have the right to express their view, to challenge the school boards, to ask.
And is it beneficial for the Attorney General to label them as domestic terrorists and direct the FBI to target them?
The Attorney General's memo deals with threats against public servants and says that threats against public servants are not only illegal, they run counter to our nation's core values.
Do you believe parents objecting at school boards are domestic terrorists?
I don't, Senator.
Do you believe Antifa are domestic terrorists?
I don't have a view about Antifa.
Do you believe the Black Lives Matter protesters who burned shops, who firebombed police cars, who murdered police officers, do you believe they're domestic terrorists?
Senator, I believe that we live in a society where people espouse different views, but what we don't want are threats.
Ms. Clark, it is
violence.
amazing that you're not willing to condemn people who are murdering police officers and firebombing cities because your politics aligns with them. But at the same time, when it comes to parents at school boards, you're perfectly comfortable with calling a mom at a PTA meeting a domestic terrorist. Ms. Clark, with all due respect, this demonstrates why the Democrat proposal to take someone with as long a partisan record as you have and to put you in charge of striking down any voting rights law in the country that you disagree with is nothing but a partisan power grab. Let me give another example, because your division has operated in a purely partisan way. The Department of Justice dismissed the civil rights lawsuits against the state of New York, the state of Pennsylvania, the state of Michigan for those governors' policies that sent COVID-positive patients into nursing homes, forced the nursing homes to take those patients, a political decision that resulted in tens of thousands of deaths. One of those governors, Andrew Cuomo, has now resigned in disgrace, and his staff had admitted they lied, underreporting the deaths that policy caused, and yet your division dismissed the lawsuit against those Democratic governors. How are we to see that as anything other than a purely partisan decision?
The letters that were issued to officials in the matters that you referenced were put together by career officials inside the department.
Career officials can't be partisan?
This department carries out its work free from political
Are you
interference.
testifying to this committee that there are no career officials in the Department of Justice who are partisan?
Partisanship does not impact the way that we carry out our
Except
enforcement
miraculously, you dismissed the lawsuits against Democratic governors, even when their policies may have caused the deaths of tens of thousands of people. You also dismissed a lawsuit that was brought against a medical center that had a pattern of discriminating against healthcare providers that, for conscience reasons, didn't want to implement abortions, even though clear federal law protects their civil rights. Why did you dismiss that civil rights lawsuit in contravention of federal law?
General Garland has made clear, and I agree, that partisanship has no place in the enforcement
Except
work
every decision
of
you
the
make
Justice
is partisan.
Department.
Your actions contradict those statements.
Your time has expired.
Thank you, Mr. Chairman. Judge Thomas, welcome. As I look at your record, it continues a pattern of the Biden administration of nominating individuals to the bench who have long careers as activists. Throughout the course of this hearing, you have explained some of your prior positions as simply representing a client. But when I look at your career, I don't see that. I see that you are passionately committed to a particular vision of the law. It has ranged from filing briefs in litigation in the state of Texas, defending race-based discrimination in university admissions, to most consistently transgender activism, and I would submit extremism. And this hasn't been one client you had in one case. This has rather been a consistent pattern that extended when you were a lawyer for the state of California, that extended when you were a lawyer for the U.S. Department of Justice, that extended when you were a lawyer for the state of New York. In 3 different jurisdictions, you have been involved in litigation on the extremes of transgender issues. And in particular, you've carved out an expertise for yourself using litigation to force institutions to allow biological males to use restroom facilities and locker facilities that are also used by girls, young girls, that are used by women. And this has been a pattern. When you were a lawyer for the state of California, you filed a lawsuit against Crunch Fitness, a gym, for not moving quickly enough to allow a biological male to use the women's locker room. When you were a lawyer for the state of New York, you filed briefs against the state of Texas, against the state of North Carolina, again, advocating for biological males to use girls' and women's restrooms. And you know, the thing I find troubling about these arguments is it seems the women and girls never have any rights. That the girls that would like to shower next to someone who is not a biological male, who would like some privacy, their rights never seem to matter. And your pattern, it's not a single case. It is across 3 jurisdictions over and over again. In the Texas case, the brief you filed said, quote, "There is no data or tangible evidence in support of the claim that allowing people to use bathrooms corresponding with their gender identity will lead to increased violence or crime in restrooms." Do you stand by that statement?
Thank you for the question, Senator Cruz. Again, as an advocate, you advocate for the positions of your client. I haven't been an advocate for 3 years. I've been a judge. And when
3 years is not very long. And my question is simple. Do you stand by that statement?
Senator Cruz, it would not be appropriate or consistent with my ethical duties to my former clients to comment on my personal views about any case that I worked on. What my duty was to advocate zealously for my clients. I have set aside the advocacy role, and I now occupy a judicial role where what you're
Judge,
guided
your
by.
brief also contended, quote, "In states where anti-discrimination protections are already the law, the predicted safety harm has never materialized." You made a bold, aggressive, factual statement, by the way. In North Carolina, you said safety concerns were, quote, "unfounded." You were an aggressive advocate, an activist advocate. And I believe the statements that you represented to the court, and those are statements that you're making as an officer of the court. I believe they were false, and they are extreme. You testified to this committee that you were not aware of what happened in Loudoun County until this morning. I find that remarkable for someone who has spent years as one of the leading activists for allowing transgender biological men to use girls' restrooms and women's restrooms. In Loudoun County, Scott Smith, who's the parent of a 14-year-old girl, alleged the Loudoun County School Board covered up the sexual assault by a gender-fluid individual against his 9th grade daughter who entered the girls' bathroom in a skirt and this individual was charged with 2 counts of forcible sodomy, 1 count of anal sodomy, and 1 count of forcible fellatio. The school district covered it up. They released this sexual predator, and the predator committed sexual assault again, twice. Why did you represent to the court that concerns about violent sexual predators committing violent crimes against young girls are unfounded and speculative? Why did you represent that to the court?
Thank you for the question. I advocated on behalf of my clients based upon the data that we had at the time, and I zealously did so in those cases and in every other case that I handled.
Were you right?
Senator Cruz, it would not be appropriate for me to comment on the merits of any personal views regarding litigation that I handled on behalf of my clients.
Well, these little girls who were sexually assaulted
let her respond.
will have a very different
respond.
assessment.
Senator Cruz,
These little girls who were assaulted. Thank you for your views, but
you're past time. Let's afford Ms. Thomas an opportunity to respond to your
perfectly welcome to respond. But as I said, the little girls who were raped in Loudoun County would have a very different assessment of whether this threat and danger is speculative or not, and you're more than welcome to respond.
Thank you. I will just conclude by saying again that I understand the difference between being an advocate and being a judge. I am a judge now, and what I'm guided by is the record before me and the law, and that is what I do now, and it's what I'll continue to do if confirmed.
Thank you.
Mr. Beckerman, thank you for being here today. I understand this is the first time that TikTok is testifying before Congress, and I appreciate you making the company available to finally answer some questions. In your testimony, you talked about all the things you say TikTok is doing to protect kids online, and that's great. But I want to discuss the broader issue here, which is the control the Chinese Communist Party has over TikTok. Its parent company, ByteDance, and its sister companies like Beijing ByteDance Technology. Now, TikTok has stated repeatedly that it doesn't share the data it collects from Americans with the Chinese Communist Party, and that it wouldn't do so if asked. It has also stated that, with regards to data collected on and from Americans, that data is stored in Virginia with a backup in Singapore. But these denials may in fact be misleading. A quick look at TikTok's privacy policy, in fact, just last night, shows there's a lot more than meets the eyes. For example, in the, quote, how we share your information section, one blurb reads, quote, we may share all of the information we collect with a parent, subsidiary, or other affiliate of our corporate group. Interestingly, in June of this year, the privacy policy was updated to state that TikTok, quote, may collect biometric identifiers and biometric information as defined under U.S. laws, such as face prints and voice prints. Mr. Beckerman, does TikTok consider ByteDance, the parent company of TikTok, which is headquartered in Beijing, to be a part of TikTok's, quote, corporate group, as that term is used in your privacy policy?
Thank you, Senator. This is an important question. I'd just like to take an opportunity first to clear up misconceptions around some of the accusations that have been leveled against the company. I would like to point to independent research. I understand that trust needs to be earned.
Mr. Beckerman, I get you may have broader points you want to make. My question is simple and straightforward. Does TikTok consider ByteDance, the parent company headquartered in Beijing, to be part of TikTok's corporate group? That's a yes or no.
Senator, access controls for our data is done by our U.S. teams. And as independent researchers, independent experts have pointed out, the data that TikTok has on the app is not of a national security importance and is of low sensitivity. But again, we do hold that to a high standard, and we have access controls.
Mr. Beckerman, we're going to try a third time because the words that came out of your mouth have no relation to the question you were asked. Your privacy policy says you will share information with your corporate group. I'm asking a very simple question. Is ByteDance, your parent company, headquartered in Beijing, part of your corporate group? Yes or no, as you use the term in your privacy policy?
Senator, I think it's important that I address the broader point in your statement.
So are you willing to answer the question, yes or no? It is a yes or no question. Are they part of your corporate group or not?
Yes, Senator, it is.
Yes, it is. Okay, so under your privacy policy, you're explicitly stating that you may be sharing data with them, including biometric identifiers, including face prints, including voice prints. Is that correct?
No, Senator. In the privacy policy, it says that if we are to collect biometric information, which we do not collect biometric data to identify Americans, we would provide consent and opportunity for consent first.
But you also say we may share all of the information we collect with a parent subsidiary or other affiliate of our corporate group, which means with ByteDance headquartered in Beijing, correct?
Under U.S. access control, sir.
All right. Secondly, what about Beijing ByteDance technology, which media reports from earlier this year showed Beijing took a minority stake in through a state-backed internet investment Chinese entity, and on the board of which now sits Wu Shenggang, a CCP official who spent most of his career in Chinese propaganda, including with a stint at the Online Opinion Bureau under the Cyberspace Administration of China, China's internet regulator. Would you consider Beijing ByteDance technology to be a part of TikTok's corporate group with whom TikTok could share all of the information it collects?
Senator, I want to be clear that that entity has no affiliation with TikTok. It's based for domestic licenses of the business in China that is not affiliated or connected to TikTok.
So are you saying no or yes or no as to whether Beijing ByteDance technology is part of your corporate group? As the privacy policy defines it, it says we may share all of the information we collect with a parent, subsidiary, or other affiliate, and presumably that's where it would fall, other affiliate of our corporate group. Is Beijing ByteDance technology a, quote, other affiliate of your corporate group?
Senator, I'm saying that entity deals with domestic businesses within China. It is not connected with TikTok.
You're having a hard time. You're answering questions I'm not asking. Again, it's a yes, no. Is Beijing ByteDance technology a, quote, other affiliate of your corporate group as your own privacy policy defines it?
Senator, I'm just trying to be clear to answer your question. That entity is based in China for the Chinese business that is not affiliated or connected with TikTok.
Okay. So that's twice you haven't answered. Last time you did it on the third time, so let's try it again. Again, it's a yes, no.
The answer is the same, Senator.
Which is?
What I just said, that entity is...
Okay. What you just said did not answer the question, so let me just repeat the question again. Is Beijing ByteDance technology a, quote, other affiliate of our corporate group as your privacy policy defines it? Yes or no?
Senator, as I stated, that entity does not have any relation to the TikTok entity.
So I'll point out it took 3 questions to get you to answer about your parent. You finally answered yes, that you can share all your information with your parent company based in Beijing. I've asked you 3 times about this sister company that is obviously another affiliate. You've refused 3 times. That may be revealing, often as Sherlock Holmes observed about the dogs that do not bark, it may be revealing that the Chinese propaganda minister that is serving on your sister company and who's been in the business of online propaganda, you're refusing to answer whether they fall under your privacy policy. That reveals, I think, a great deal, unfortunately.
Senator, with all due respect, I'm just trying to be accurate here. There's a lot of accusations that are just not true, and I want to make sure that it's
okay,
clear.
I'm going to give you one more chance, and my time is over. But look, in baseball, 3 strikes, you're out. Tonight, the Astros are going to begin winning the World Series. Let's see if a 4th strike, you could actually answer the question. And it's a simple yes, no. Is Beijing ByteDance technology a, quote, other affiliate of our corporate group as your privacy policy defines that term?
Senator, as I pointed out before, my answer is the same.
Yes or no? You didn't answer.
Senator, I appreciate you're trying with gotcha questions. I'm just
It's
trying to
it's
be,
not a gotcha question. I'm asking about your
I'm just trying to be
policy.
truthful and accurate about the
Are you
connection
willing to
between-
answer this question, yes or no?
Senator, I answered the question.
You have not answered the question. Is it another affiliate, yes or no?
Senator, I stated a number of times that entity is a domestic entity within China for licenses there, and
apples are red. You stated something that is not the question I asked. Is it another affiliate as defined under your privacy policy? Yes or no?
Senator, I answered.
You're here under oath. Are you going to answer the questions?
I answered the question.
Or were you instructed not to answer this question?
No, Senator. I'm just.
So you're just not refusing to answer it because you don't want to?
Senator, it is not affiliated with TikTok. That's your question, and that is the answer.
So your answer, I want to be clear because you're under oath. Your answer is that Beijing ByteDance Technology is not a, quote, other affiliate of our corporate group, as your privacy policy uses that term. This is a legal question with consequence.
Senator, I understand the question. As I pointed out, TikTok is not available in China. That is an entity that is for purposes of a license of a business in China that is not affiliated with TikTok.
So for the record, you're refusing to answer the question.
I believe I answered your question, Senator.
Yes or no? Tell me which one it is. Just give me one word, yes or no.
Senator, I answered the question.
You're not willing to say yes or no.
It's not. It was not a yes or no question. I want to be precise.
Okay,
I want to be.
Is this company another affiliate as defined in your privacy policy? That is binary. There's not a maybe. It's yes or no.
Senator, the way I answered, I'm not aware that that is the answer to the question.
Okay, so you're refusing to answer the question. That does not give this committee any confidence that TikTok is doing anything other than participating in Chinese propaganda and espionage on American
Senator,
children.
that's not accurate. And again, I would point you to
if it were not accurate, you would answer the questions, and you have dodged the questions more than any witness I have seen in my 9 years serving in the Senate. That is saying something, because witnesses often try to dodge questions, but you answer non sequiturs and refuse to answer very simple questions. That, in my experience, when a witness does that, it is because they are hiding something.
Senator Moran.
Mr. Dugan,
Sorry, I don't understand your...
over the last several years, we've seen repeated efforts in Democrat-controlled cities and states to effectively decriminalize theft. California, for example, said that any theft under $950 is no longer a felony, and we won't arrest you if you're under that dollar figure. A recent NBC News article stated that both CVS and Walgreens say shoplifting in San Francisco outpaces thefts at their stores across the country. Pretty common sense. If you remove or greatly reduce the penalty for stealing things, theft gets worse. What exactly are the figures for non-employee theft in CVS stores around the country? And in particular, how do the rates of theft differ in jurisdictions with so-called progressive prosecutors who decline to prosecute shoplifting versus jurisdictions where law enforcement is enforcing laws against theft?
Well, thank you for that question, Senator. Unfortunately, I'm not going to be able to disclose CVS financial information about losses. But if you allow me to comment, this is not a big city problem, right? Decriminalization is contributing to the problem. You're right, sir.
Is there more theft in San Francisco than elsewhere?
No, sir.
There's not?
Not relative to the amount of stores and market share that we have. It's higher. But
so NBC News was wrong when they said that?
I can only speak to what I see every day on the ground, Senator, and I follow these criminals day to day from state to state and city to city.
So CVS would support other jurisdictions legalizing shoplifting up to $950?
CVS does not support legalizing shoplifting.
Why not?
Senator.
Why not?
We're not going to endorse criminal activity.
But you're saying it has no effect.
I never said it had no effect.
You said there's not worse shoplifting in San Francisco. I find that highly dubious.
No effect, Senator.
Does it have an effect or not?
Yes, of course it does.
What's the effect?
The effect is shoplifting is completely different than organized retail crime. If you're talking about shoplifting, that's a whole different dynamic than organized retail crime.
And so my question is, what's the effect? You guys have the data.
I'm sure I understand your question, Senator. Is there an effect? Do we take losses to shoplifting Yes, like every other retailer.
And are
By the
they
law.
greater in jurisdictions that effectively legalize it?
No, they're not.
So then why would you oppose every jurisdiction legalizing shoplifting? Your questions are not, your answers not making any sense, sir.
Well, I respectfully disagree. I think it's making perfect sense. What I'm saying, Senator, is this crime goes to all 50 states. It's not a big city problem. Absolutely not.
So why would you oppose every
just as much-
jurisdiction legalizing shoplifting? Sir, why would you oppose every jurisdiction legalizing shoplifting?
We're not going to. Why are we not going to oppose
Why?
legalizing shoplifting?
Yes.
No, we're not going to do that, Senator. We're not going to endorse criminal activity. But shoplifting is a different dynamic than organized retail crime. And what I'm here to testify about today is that organized retail crime affects every city,
that's really quite
including the
remarkable.
major cities in Texas.
That's really quite remarkable. Let me ask a different question, which is you go into great detail about organized criminal organizations, but I want to point to you to something in Ms. Campbell's testimony, where she cites the work of J.P. Kennedy, who's written a lot on the subject of theft. And one scholarly article that Mr. Kennedy wrote, Functional Redundancy in Response to Employee Theft Within Small Businesses, has an interesting paragraph on the second page which is relevant to this discussion. It says, quote, "It has been estimated that employee theft within the United States is 10 times more costly than all forms of traditional street crime, and that it cost victimized businesses in the U.S. economy as much as $400 billion a year. Furthermore, employee theft is estimated to cost victimized businesses significantly more than non-employee theft within the same businesses." In your experience, what is the relative magnitude of employee theft versus non-employee theft for retailers?
My scope at CVS, Senator, is to investigate the external part of the theft. I don't have the internal figures necessarily at CVS. I will say overall, as the president of the Coalition of Law Enforcement and Retail, that internal theft is down. I could certainly provide you a report with those figures attached to it, Senator, if you'd like me to. But
Do you have any judgment as to which is bigger, employee theft or non-employee theft?
Well, I might be a biased opinion there, Senator, because I'm in the street every day working on organized retail crime. I see the harm that it does every day, why we need this federal legislation. So I see it.
Sir, with all respect, I'd like you to answer my question. Do you have any judgment as to which is bigger, employee theft or non-employee theft? And in particular, Mr. Kennedy says employee theft is 10 times larger.
No, I would disagree with that assessment.
Do you have any judgment as to which is bigger, employee theft or non-employee theft?
Most recently, over the spread of this epidemic, I would say non-employee theft.
Okay, thank you.
You're welcome.
I want to thank the witnesses for...
Elliott, when you were endorsing John Curran's nomination to the New Hampshire Circuit Court, you stated that Curran, quote, reads the people, he reads the facts, he's not overly focused on the law, and he understands what the jury might be thinking about, and those same qualities that make him an incredible trial lawyer will make him a fantastic judge. Why do you think it is a beneficial trait in a judge to not be, as you put it, overly focused on the law?
Thank you for the question, Senator Cruz. And I have to say at the outset that that is not what I intended to say. And so I apologize if it's given the impression that I don't think judges need to follow the law. If I were given the honor of a confirmation, obviously, I would follow the precedent faithfully and without any bias. What I intended to say about John Curran, who was then my law partner and is now on the circuit court in New Hampshire, is that he is not overly formal. I didn't mean to suggest that he doesn't follow the law. It's that he doesn't, there are two different types of trial lawyers, as I'm sure you've seen, and some are focused very much so on explaining the law in a dry, kind of borderline pedantic way. And then Attorney Curran was really much more about connecting with the judge and the jury and the parties in the courtroom. And I thought that given what he was nominated to be, which is a circuit court judge doing, small claims and misdemeanor cases, that his ability to connect with the parties in the courtroom would be an asset to the bench.
Okay, thank you. Judge Lopez, before joining the bench, you represented an illegal alien who had re-entered the country after being deported, and you argued that it was reversible error for the trial court to instruct grand jurors to follow the law even if they disagree with it. As a judge, will you instruct jurors and grand jurors to follow the law, even if they disagree with it?
Thank you, Senator Cruz, for that question. Absolutely, I will.
Why then did you argue it was reversible error to do that?
Senator Cruz, I don't recall that case. I don't recall making that argument. As I sit here now, I would not be able to speak to the facts of that case. I can assure you that if I'm fortunate enough to be confirmed, I would do what I've done over the past 3 years as a magistrate judge, which is to faithfully apply the law, and I would instruct jurors to do the same.
Judge Menendez, during your investiture in 2016, you delivered a speech discussing your judicial philosophy. You stated, "I was hoping by now I would have the beginnings of a judicial philosophy, a simple mantra that could help me do this new and difficult job." No such luck, but the verse from Micah that my mom referenced in her invocation is one I keep in my head, maybe because I hear my pastor say it so often. Do justice, love mercy, and walk humbly. Good advice for a judge. Judge, now that you've been on the bench for 5 years, how would you describe your judicial philosophy?
Thank you for that question, Senator. I think it's important, first and foremost, for a judge to apply the law, regardless of their opinions about it, squarely to the facts in the cases that come before them. And that's what I've endeavored to do at every turn, Senator. I would also say that it is important that the parties that come before me feel that they are heard, that I am impartial, and that I am always prepared. I'm not sure I've got a mantra yet, but I am very aware of the role of a judge and the importance of applying precedent.
Judge Ota, you were actively involved with the Lawyers Club as you co-chaired the Reproductive Justice and Women's Advocacy Committee and the Diverse Women's Committee, and you wrote several articles for the organization. In a 2020 press release, the Lawyers Club criticized the U.S. Supreme Court decision in Little Sisters of the Poor versus Pennsylvania. The press release said that the decision to allow religious and moral exemptions to the contraception mandate in the Affordable Care Act was a, quote, devastating blow to women's reproductive justice, and the decision perpetuates inequality. Do you believe that Supreme Court precedent upholding conscience protections and religious or moral exemptions are legitimate and binding on you as a judge?
Senator, thank you for the question. I take the First Amendment rights to free exercise of religious liberty very seriously. It is a foundational right. It's one that's enshrined in the Bill of Rights. And if that issue were to come before me in the courtroom, I would give it the due respect that it is owed. I would faithfully apply all Supreme Court precedent, and I would decide the case before me on the precedent and the facts without regard to previous advocacy positions, without regard to any personal or political beliefs that I may have on the issue.
Did you agree with the Lawyers Club press release blasting the Supreme Court's Little Sisters of the Poor decision?
Senator, the 15-member board of directors of the Lawyers Club of San Diego released that statement. I was on the board of directors at that time.
Did you agree with it?
Senator, that press release issued by the Lawyers Club of San Diego was before I became a sitting judge. Currently, as a sitting judge...
At the time it issued, did you agree with it? That's a yes or no. You either agreed with it or you disagreed with it.
Senator, currently as a sitting judge, I make my decisions.
I'm asking you at the time the press release went out, not today.
Senator, at the time that the press release went out, I was on the board of directors of the Lawyers Club of San Diego that voted to release that press release. However...
Did you agree with it? Did you vote to release it?
Yes, I voted to release it. However, as a sitting judge, my personal views, any previous advocacy statements, don't enter into my courtroom. That would be inappropriate and a violation of the judicial oath that I take very seriously as a sitting judge.
Thank you. Now, I have to say, in the past year, we've seen a pattern of judicial nominees from President Biden, where over and over again, nominees have records of being partisan and ideological extremists, rather than men and women committed to following the rule of law. And looking at your record, I'm concerned that this nomination follows that pattern. You have had predictably knee-jerk left-wing views on the Second Amendment, on immigration, on the death penalty, on crime. I want to start with the latter. On the death penalty, you oppose the death penalty.
Senator, I've never had a, well, let me say this before I became a judge, I never indicated any view regarding the constitutionality of the death penalty. As a sitting judge, I have had capital eligible cases. There were not seeks of death in those cases. I was fully prepared to apply the law in those cases, and the death penalty is constitutional. I would apply any Supreme Court and Second Circuit precedent.
So, but you've spent, what, 10 years as a federal judge? Have you imposed the death penalty in any case?
I have never had, I've had cases that were death eligible, and you know the process involves the local office and Maine Justice determining whether or not to seek the death penalty. The death penalty has never been sought in any of the cases over which I've presided. That process takes time, so I have presided over cases that were death eligible.
We've got limited time, so you have not imposed the death penalty in any case you presided on, correct?
It would have been unlawful for me to do so. That's correct. No case.
So let me start with my initial question. You oppose the death penalty?
Senator, I don't have a view that could be expressed, and I can.
You don't have a view. You spent years litigating. Let's say you led an amicus brief in Bays versus Reese, trying to challenge the death penalty. You participated in a Supreme Court panel in 2007 discussing Bays, and you also discussed Kennedy versus Louisiana. That happens to be a case I know well. I argued Kennedy versus Louisiana. It dealt with a truly horrific crime of a 300-pound man who brutally raped his 8-year-old stepdaughter, so much so that it left permanent, serious injuries to that young girl. Your notes for the panel at the time said, but the actual question and issue has nothing to do with innocence. If you have consistently litigated against the death penalty prior to your time as a judge, and yet you're not going to answer whether you oppose the death penalty or not?
Senator, my personal views have nothing to do with my application.
You didn't say, you said you didn't have a view. You may disagree that your personal views are relevant, but that's not the same thing as not having one. I mean, we're adults here. You oppose the death penalty.
Senator,
that's okay. That is a view people can have.
Senator, I can assure you, in any death case before me,
Okay, but you're not going to answer the question, but there's a difference. You can argue your personal views are irrelevant, but you're just refusing to tell them that. Well, let's shift to criminal justice generally. The Biden administration keeps nominating radicals when it comes to criminal justice. 2 of the senior officials of the Department of Justice are among the leading advocates for abolishing the police. The U.S. Attorney now in the District of Massachusetts, as a prosecutor, put out a list of 15 crimes she would not prosecute. And as I look at your record, you have a pattern on so-called compassionate release of releasing violent criminals. So, for example, in United States versus Stephen, the defendant had been indicted in part of what the Department of Justice called, quote, the largest gang takedown in New York City history. The defendant was one of 120 members of rival street gangs that were busted for racketeering, narcotics, firearms offenses. He was later arrested for violating the terms of his supervised release. Last year, you set him free, and that was bad judgment. And what's remarkable is that you released this criminal without even waiting to hear from the government whether he was a threat to society. In fact, the government planned to present you with substantial evidence from video surveillance footage and testimony from 2 law enforcement officers that he was unlawfully carrying a firearm and so was a threat to society. Why did you release a violent criminal without even waiting to hear from the prosecution about whether he was a risk to the community?
Senator Cruz, I have had many cases during the pandemic, as all judges have, regarding compassionate release in each of them. And actually, I think that was not a compassionate release case, if I recall correctly. But forgive me, I'm not sure. In each of those cases, I have analyzed the factors under First Step Act and 18 U.S.C. Section 3553A. By and large, the majority of cases, compassionate release was denied.
Okay, let me try again because my time has expired. If you would answer the question I asked you. which is why did you release this violent criminal without even waiting to hear what the prosecution had to say about whether he was a threat to the community?
Senator, I don't have a memory of that procedural posture. I have to say, my practice, of course, is to hear from both sides before issuing decisions, either in writing or orally. So as I sit here, I don't know what you're referencing.
Thank you.